For today's story, we cover more about Letitia Stauch, and we discuss more about how the peanut butter is sending her secret messages in jail. For today's story, we are covering yet another letter from Letitia Stauch to the judge. The first letter that we read was so much fun, wasn't it, ladies and gentlemen? It was so much fun. We had so much fun together. I remember having fun. You remember having fun. Now we're going to read even more fun. So let's read some more words from Letitia Stauch, totally innocent woman who sees the messages in the peanut butter. Let's get started with this. Conflict hearing information. Judge Werner, February the 21st of 2021. On February the 19th of 2021, I was unable to talk with Judge Bain about my conflicts with my defense team due to the actual privacy of the booth and the transportation over. I explained in detail to him, expressing my concerns of privacy. I had a very difficult morning mentally because I'm not mentally well. You don't say. One of the main issues with my attorney is their lack of ability to gather evidence. Due to this, I find little value in the term expert. First, they're unable to obtain my medical records from Charleston, South Carolina. Oh, she did mean South Carolina. When I finally paid firm in South Carolina to obtain them. In 2016, I was diagnosed with something that's been redacted and received treatment before work for over 20 hours of care. The school district even provided extra services and later let me medically resign due to the ongoing reality breaks. Yeah. In 2018, I was hospitalized in Canada, crossing the border for 2 days and completed more of my treatment when I returned. I tell you this because it sets the stage for why I cannot work with my attorneys. I signed release forms for them to get all this information so they'd have a better understanding of why I'm all over the place some days. I asked them to use the info from my non-biased doctor who worked with me for more than 2 hours, but instead they sent a lady who was clearly an actress and friends with the DA. What? She spoke about him in an unprofessional manner, their history, and his election. Now, I'm sure all this was true, but I thought she worked for the court, not one particular side. My attorneys did this to make me look like a perjurous individual. Instead, it was malfeasances on their part. I have included several reasons to support my claim as I keep a timeline of these conflicts. Communication is broken beyond repair. I explained these issues to Judge Bain, including the lack of access and visitations in complete detail. Inconsiderate of evidence. Since March 2020, I asked my attorneys to preserve the GameStop footage to locate the Texas police officer with whom I spoke and to get the cruise passenger list. Instead, they spent many months contacting my family for mitigation. When asked certain things, they kept saying they will let the investigators know. 1 year later, same answer. My evidence. I haven't physically seen any while being held at the jail. Yes, COVID, but inmates were still being held as our constitutional rights were adjusted. Overlooking statute and evidence. They overlooked the competing statute about video recording. Human error? Okay, this happens sometimes with evidence in which me, the non-expert, has to provide corrections to the evidence. I'm sure you know more about video recording than your attorneys do. Sharing. They were texting my family and giving them info that they should not have, causing several disputes. My judge. They filed that motion knowing this county would not grant me new attorneys to sabotage my chances of a trial by judge. They knew I wanted to present evidence to him without exposing any info on my son's father. However, they created incorrect conflicts instead of addressing the real issues. They could have filed the pro se only instead of talking about my defense to sabotage trial by judge. Defenses. Indeed, I am innocent, but I will not put myself or others in danger running the defense against my biological son when the system is letting two men run free who were involved. One is a prominent member of an independent business. They used the NGRI, that be the rent stuff, to get hearing. Knowing I'm not guilty to cover up their lack of representations, although I had bouts of insanity and still do, I believe it. I did not murder or abuse anyone, nor would that be a defense, because my understanding is that you actually did do it. However, I'll protect my bio son and will protect the drugs and documentation for my son. Actually, insanity is a defense. Now, this is one of the states that doesn't allow you to do a not guilty by reason of insanity, but they let you do it otherwise. So some states have a plea called not guilty by reason of insanity, and they do that as a separate thing. Some states don't. But you can still effectively plead not guilty by reason of insanity, because what you're doing then is you're attacking the mens rea, you're attacking the mental element, right? Many of these crimes, in fact, all these crimes require a certain mental state. They require, for example, intent or knowledge or something, right? So if your defense is, I was insane, right? Then you can't necessarily plead not guilty by reason of insanity. But you can say, hey, wait a second, I'm not guilty because I was insane at the time, and therefore I did not have the capacity to have the intent because I was insane. So some states do it this way. So she's kind of right. She can't, strictly speaking, plead insanity, but insanity is a valid defense. You just have to go about it slightly differently. And the Supreme Court has said that's fine. You can do it that way. That's also fine. So yeah, that works. Ryan Holiday says, why can't we plead insanity when blackout drunk or on drugs? The intent isn't there. Aha. A great question, Ryan. So we get to talk a little bit about general intent crimes and specific intent crimes. So some crimes are general intent crimes. You just have a general intent, and some are specific intent. So the biggest distinction between the two is you can only use the fact that you got drunk or you were on drugs in a defense to a specific intent crime, not general intent crimes. So if this assumes, of course, that you willingly took the alcohol/drugs, right? So you willingly put yourself into the inebriated state. So that your intent was there at the time you took the drugs. You willingly put yourself into a lower state. And because you willingly put yourself into a lower state, you can't use the drugs or alcohol as a defense in general intent crimes. But there are a host of crimes that are specific intent in which you can use drugs or alcohol because you were unable to form specific intent to do those specific crimes. So there's your answer. It depends on what crime you're being committed with. I hope that was helpful. The truth is the court is holding the wrong person for the wrong crimes. This whole process has been nefarious, from denying me attorneys, threatening me in the bathroom away from cameras to confess. They've been threatening her in the bathrooms, taking advantage of me being delusional, threatening my other kids' freedoms or else, etc. I am going to keep making it known, sir, just how much the state has done wrongfully in this wrongful incarceration. I will continue to be an advocate for myself because I am not a murderer, and the level the prosecution goes through to promote the wrongful conviction is absurd. Truth is, they could see a video from someone else, and they would dismiss that person as a lunatic. They have far too much invested in this wrongful incarceration to admit they are wrong. Well, that can sometimes happen, but I'm less convinced it's happening here. For these reasons, and because my defense team is in cahoots with them, I'm left with no other choice but to represent myself. Denying me my rights under this Constitution has happened throughout this process, from the detectives, the jail, and now my legal team. Every day I'm getting worse mentally due to inadequate representation and being held hostage for a crime I did not commit. These are my conflict issues and my reason for asking to go pro se. As always, thank you for your time. Wow. So, my friends, that brings us to the end of the interesting letter number 2 in the ongoing case, and I assure you will not be the last in Letitia Stosh matter. This woman is, happy. It's a fry short of a Happy Meal over here. The peanut butter is talking to her, and so it's a thing. So we'll continue to cover this ongoing case and this ongoing train wreck, and at least for the moment, that brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.